For the last of the lectures that last tonight, I will take as my topic, what is inclusion? I'd like to present you with three stories, three episodes that present neatly a recurring problem with claims for inclusion in institutions by outsiders. In all three cases, proponents of inclusion saw themselves as carrying forward a mandate that had its origins in the Supreme Court's decision in Brown versus Board of Education. In all three cases, the claimants began by asking for a simple removal of restrictions on their inclusion within mainstream institutions. But in all three cases, the claimants wound up asking much more than this, asking for radical changes in the basic rules that govern the operation of the institution. I'd like to suggest that it is in the nature of claims for inclusion that ground themselves in the narrative that begins with Brown versus Board of Education, to slip from what I call mode one, asking for simple removal of restrictions, to what I call mode two, asking for radical changes in the rules of the game that govern the institution in question. For case number one, I'd like to take you back to the year 1960, before even I was born, and to a city called New Rochelle, New York. The case involved the Lincoln Elementary School, which nearly all of the city's black children attended. That was no accident, because the city had deliberately built Lincoln as a school in a black neighborhood, deliberately as a segregated school, drawing its boundaries to ensure its racial character. Black parents organized a boycott of the school and eventually sued. But what exactly did the parents want, and how would they get it? It was easy for city officials to segregate Lincoln because there was residential segregation, but that residential segregation was itself no accident. As much recent scholarship has shown, a host of federal, state, and local laws and actions fostered and even mandated that housing in places like New Rochelle be built to be occupied for blacks or by whites, but not by both. Indeed, to undo segregation in Lincoln would require the black parents to undo just about everything about how the town had been organized. That is exactly what the black parents proceeded to do in their lawsuit. They claimed that any school that happened to be nearly all black was unconstitutional. That, of course, would mean that any action the city took that resulted in an all-black school would be unconstitutional. They were asking the city to change the basic rules about school assignments, neighborhood boundaries, housing construction, and the like to ensure integration. What had begun as a Mode 1 claim, a Type 1 claim, that the city had deliberately segregated its black students, suddenly transformed into a Mode 2 claim, that the city had to change the basic ground rules that governed itself to ensure inclusion. For case number two, we have to fast forward 8 years to 1968, by which time I had been born, and look west to the campus of San Francisco State University, where the first time significant numbers of black students were attending the university. Many things had kept them out previously, from discrimination to a host of imposed inequalities that kept institutions such as this out of the reach of most potential black students. In the aftermath of Martin Luther King's assassination in 1968, however, black students began agitating for increased efforts to recruit more qualified, poor, urban black students to the university. But they quickly slipped into Mode 2 claims. Among other things, they demanded the admission of a specific number of what they called, a specific number, quote, 400 ghetto students. They demanded the hiring of 9 minority professors. They eventually demanded and got the creation of a program in black studies. Similar demands were made by black students at over 200 universities in 1968 and 1969, including this university. And in each of these cases, in most of these cases, the demands for simple removal of barriers, the claims began as claims for simple removal of barriers to the attendance of more minority students, but they quickly transformed into radical changes to the basic rules that governed the university. That's case number 2. Case number 3, I'd like to turn to a more recent example. The push for what is now called intellectual diversity at universities. This claim is directly connected to the presence of groups that once had only a token presence in many institutions of higher education. As recently as the 1970s, conservative students felt excluded at many universities, but with the increase in the number of conservative students, naturally came the demand for the inclusion of more conservative professors. Intellectual diversity as a term means that universities should appoint more conservative professors, assuming that the majority of the professorate is liberal. If the claim is that there's hostility to or discrimination against professors with certain political orientations in the hiring process, this would be an entirely conventional inclusion claim in the form of the first mode. But the call for intellectual diversity allows the claim to slip easily into the second mode. For it is hard to keep from slipping into an argument that political beliefs should play a role in hiring decisions. The basic problem is the same one faced by the black students at San Francisco State. While particular instances of overt hostility or explicit exclusion can be found, most of the evidence for exclusion tends to rest upon the simple fact that members of the excluded group are not found in great numbers within the institution. That is, when the claim for inclusion is articulated as one for intellectual diversity, it is difficult to keep the argument that political beliefs should be kept out of the hiring process from shading into the argument that political beliefs should be part of the hiring process and should be incorporated into our very definition of academic merit. Claims that institutional policies should promote intellectual diversity inevitably shade into a second mode claim, inevitably present a fundamental challenge to the basic rules of the operation of the university. Now, what I've said so far gives us some basis to think through the current movement for inclusion that is roiling my own law school. Students, disproportionately minority students, have complained of microaggressions at the university, an always hard to define concept, and also specific acts of Mode 1 exclusion. They have called for unprecedented changes, like a mandatory curriculum that focuses on marginalized narratives and white supremacy. They've called for things that constitute a fundamental challenge to the rules that govern the university. By now, such claims should be familiar. They're similar to the pressures that black parents, 1960s university students, and indeed advocates for the disabled, for non-English speakers, and for political conservatives have placed on the ground rules that govern the institutions of our society. Some have criticized the law student protesters for not citing specific instances of Mode 1 exclusion, but it is in the nature of such claims that they shift quickly into Mode 2, where a host of often hard to name subtle phenomena keep black residents out of white neighborhoods, poor minority children out of universities, and political conservatives out of law teaching. Others criticize the students for their passion, for their seemingly blithe willingness to set themselves in opposition to the basic rules that govern the university. Such criticism, too, would be familiar to those many groups whose claims have slid inexorably from Type 1 to Type 2, from Mode 1 to Mode 2. Indeed, if they did not provoke such criticisms, they would not be truly movements for inclusion. So to return to my topic, what is inclusion? Or what is inclusion among groups that claim the mandate of Brown versus Board of Education and try to apply that mandate to the exclusion of specific groups from institutions? Well, as she observes, inclusion is not just about the specific claims that have been made. In fact, in many of the instances I've listed, some of the claims, many of the claims are controversial and should be controversial, and not all of them are actually even good things. Inclusion, sure, is also, surely, is not just a type 1 claim, is not also just a claim that specific acts, rules, specific inclusions keep the excluded group out. Inclusion, in fact, is an invitation. Claims for inclusion that slide inexorably into from mode 1 to mode 2, whether they be articulated by black parents, students, or political conservatives, in fact, are invitations to us to think about what they put on the table. The basic ground rules of our institution, our basic assumptions about the world, things that we don't consider and perhaps we should. And I would think that those kinds of questions, those kinds of problems are entirely worthy of our attention. Thanks very much.